Good morning, Your Ladyship, the Honorable Chief Justice, Your Lordships, Justices of Appeal, Your Lordships, Justices of the Supreme Court, His Honor the Chief Magistrate and Resident Magistrates, Registrars, learned DPP, members of the Bar, staff of the Judiciary, members of the CAJO attending, all other attendees. The Honorable Chief Justice Peter Jamadar of the Caribbean Court of Justice and current Chairman of the Caribbean Association of Judicial Officers is here with us this morning, and we are very, very happy to welcome him to JEI Week 2023. Mr. Justice Jamadar will be presenting today on constitutional interpretation. We look forward to a very informative presentation, and we've circulated his full bio to you in the meeting programs, and we'll circulate it again in the meeting chat. Justice Jamadar has asked me to indicate that this morning's presentation will be a very interactive presentation. So he's asked for any questions or comments to be placed in the chat throughout, and there will also be several discussion points throughout the meeting. So without further ado, I turn you over to Justice Jamadar. Good morning, Justice Jamadar.
Good morning, Antonio, Chief Justice. I am expecting that all protocols can be accepted, and I can begin. First, let me say that it is my pleasure to be part of your week of judicial education training and to join you virtually, albeit. This morning, I've been asked to chat with you a bit about constitutional interpretation from the CCJ, the Caribbean Court of Justice's perspective, some insights and approaches. Helping me, assisting me, and you will hear from her during parts of this presentation, is Larissa Pena. She is the legal officer with the CAJO and judicial counsel at the CCJ. Yeah, so there's Larissa. What I'm hoping is that this morning we have 2 hours to spend together. That's a lot of time to be spent together in virtual training, but I'm hoping that we can make it a little bit interactive. There are 4 built-in discussion points, but I'm going to encourage you to drop questions or comments in the chat. Both Antonio and Larissa will monitor the chat and will bring those questions or comments to my attention at appropriate times, maybe pausing with them to wait until we hit the discussion points. Some of what I'm going to say may be well known. Some of it may be a little new and novel, and some of it may be challenging. One thing that I am going to do is to make some reference to the Privy Council approaches as they sort of correlate to what the CCJ is doing. So with that sort of introduction, maybe to what I hope to achieve and to a map, I think I can begin. At the end of this, what my objectives are is that each one of you will at least know a little bit more about the jurisprudence of the CCJ around constitutional interpretation. 2, understand a bit more about the points of divergence with the Privy Council, which is your final court, and as well, points of commonality. The 3rd objective that I have is to provoke you into maybe thinking in new ways about constitutional interpretation. So those are the 3 objectives. Some knowledge and insight about the CCJ, some information about points of divergence with the Privy Council and points in common, and a little bit of provocation. So with that, let's start. I thought that the place to start is really to share with you something that I said very recently on the 3rd of September. I was asked to do a little talk. The Hewlin Law School in Trinidad celebrated its 50th anniversary. And I made the point that the CCJ, in recognizing the distinction between constitutional supremacy, which governs Anglo-Caribbean independent states, and parliamentary supremacy, which dictates United Kingdom approaches to legal interpretation, the CCJ has been able to overcome some of the hurdles that continue to plague the Judicial Committee of the Privy Council which I will come to, of course, in the course of this morning's chat. But in doing so, what the CCJ has been able to accomplish is been able to, in my opinion, respectfully, to forge a relevant and socially developmental Caribbean jurisprudence. And I, of course, underline those words, relevant and socially developmental. A little bit of provocation to start. It's always good to provoke early on, to poke the bear, as they say. In June 2023, in the Commonwealth Lawyers Association publication News, there is this article, Unconscionable Decisions of the Privy Council for the Caribbean, Deliberately Obtuse or Just Unfamiliar. And this is what the author of that short article says. I have argued in various publications during the last few years that the Judicial Committee of the Privy Council has been hindering the progress of human rights in the Caribbean. As we go through today, you will have to make that assessment for yourself. The author cites 3 decisions. I'm going to focus really on one in the course of our time together. That's Chandler. He says the JCPC, by virtue of these decisions, is failing in its legal role of a constitutional court to expound fundamental rights. And he says further that applying the JCPC's ruling in Chandler, which I'll talk about later on, prima facie, it would lead one to the inevitable conclusion that, regardless of how inhumane or degrading certain laws are in Caribbean states, they are nonetheless constitutional and hence enforceable in the eyes of the JCPC. So why should I start with that kind of provocation? Because in a sense, what is the sine qua non of what the CCJ has been doing in the realm of constitutional interpretation is actually finding ways to uphold fundamental rights. All of our jurisdictions, whether independent Caribbean states or territories, have a common socio-legal history. And I think this context is an important point of departure for today's conversation. There are 18 Anglophone independent states and overseas territories. They form the Commonwealth Caribbean community. And of course, we all have a shared common law legal tradition, which is rooted in a common colonial experience. I think it is not an unfair comment to say that the socio-legal history, and notice it is socio-legal, of Caribbean peoples reflects an aspirational struggle for Caribbean authenticity, agency, integrity, identity, and self-determination. What I want to suggest, however, is that Caribbean constitutionalism is the legitimate warrant for and writ of freedom for these societies. And those two words, those ideas of Caribbean constitutionalism as the vehicle for freedom is something that I want you to keep at the back of your minds. At the heart of the struggle for Caribbean authenticity, agency, integrity, and identity, and self-determination actually lies the work that we do. Who is the we? We is Caribbean attorneys and judicial officers. And in what sphere? In the sphere of constitutional interpretation. I want to suggest that that work is at its best when it is developmental and evolutionary. Now, what are contexts? Well, I don't think I need to remind you, but maybe it's worth doing so. Anglo-Caribbean states have a common colonial history that includes Native American genocide, African slavery, Indian Chinese, with a bit of Portuguese indentureship, all in fact legitimized in law. I'm not going to give you the details, it's on the slide, and at the end, Antonio will share all these slides with you. But of course, we know when British slavery began, when it was abolished, and so on. The real point that I want to focus on here is to understand that these colonial laws were all received and incorporated during an era when a focus on fundamental rights was not paramount. So these laws were received either in pari materia with Britain and through a process of reception. And all of our jurisdictions have laws which provide for reception in one form or another. To come back to this, I think this is significant. that as a people, as a society, as a Caribbean society, and as individual territories, we have been formed and shaped in the context of crimes against humanity. Genocide, slavery, forced labor, and human trafficking. That is an unavoidable part of our socio-legal and historical context. Another part of our context is, since independence, which, and some of you may know, some of you may not. In fact, the first Caribbean country to gain independence was Haiti in 1804, then the DR in 1844, Cuba in 1902. In terms of Anglo-Caribbean territories, countries, 1962, Trinidad and Tobago and Jamaica, in 1966, Barbados, and St. Kitts and Nevis in 1983, among the last to do so. All of these independent Caribbean states adopted written constitutions which featured human rights. This idea of the emergence of human rights is there's a nice little parallel that I think helps us in our conversation. Running parallel to the independence movement in the Caribbean. Remember, in 1962, it's Trinidad and Jamaica, and then in 66 it's Barbados and ongoing. In 1964, the Murder Abolition of the Death Penalty Bill was tabled in the UK and passed. It temporarily abolished the death penalty for murder in Britain for a 5-year period and substituted life imprisonment. In 1969, 5 years later, in the UK, the death penalty was permanently abolished for murder. However, in the newly independent Anglo-Caribbean states, the mandatory death penalty for murder was an existing law that was saved by savings law clauses contained in their independent constitutions, constitutions created by the colonial office for these independent states. So you see something happening here, this divergence. Death penalty, mandatory for murder, is saved in the constitutions by reason of savings law clauses. But in England, in the UK, 64, 2 years before, in the first set of Anglo-Caribbean independence constitutions, the move towards a change is happening because of an interest with human rights. How does that play out? Well, what are some differences? Because this is a conversation principally with the Turks and Caicos. British Overseas Territories, like the Turks and Caicos, also have written constitutions. One important difference is in the fully independent states like Trinidad, Jamaica, Barbados, constitutions are the supreme law. However, in the Turks and Caicos, the UK Parliament is supreme. And I'm sure for those of you from TCI, you know the case of RV, the Secretary of State for Foreign and Commonwealth Affairs. It's 2020 Privy Council decision. Former Premier of TCI challenged the changes made to the Constitution by an order in council, which were made following the allegations of corruption and financial mismanagement. And of course, what is affirmed is that by the West Indies Act 1967, the Crown in England can make laws for peace, order, and good government of the TCI through orders in council. Now, this idea of orders in council is interesting because that is actually how the first independence constitutions are created and come into being in the fully independent states in the Caribbean. So what you can see is this legal basis for a fundamental distinction between parliamentary supremacy, UK parliamentary supremacy, both in the UK and for the territories, and of course, constitutional supremacy. Orders in council were not exempt from being challenged, but on limited grounds, such as legality, rationality, and procedural propriety. There are important similarities. Though the constitution in the territories, in overseas territories like TCI, are not supreme in the same sense as the independent states, still there are governing laws. So, for example, laws made by the local legislature must conform with the constitution. Actions of the local executive, similarly. The local legislature and executive, they derive their power and duties and their context from the constitution. And of course, the judiciary has the power to review laws made by the local legislature and actions of the executive. So you see some convergence, but at the heart of it, the distinction lies in what we're going to come to, the difference between constitutional supremacy and parliamentary supremacy. In your realm of the Caribbean, your national tree is the Caicos pine or the Caribbean pine. And I'm told, I have not walked there, but I'm told there is in Middle Caicos something called the Caicos Pine Yard Trail, in which one can enjoy the presence, shade, and ambience of these pines. Why do I talk about your national tree? Because I think trees can teach us a lot about constitutionalism. If we're willing to look and we have the eyes to see. A constitution is very much like the TCI Caribbean pine tree. We see and use the wood of its text most often, but we need to constantly remind ourselves and to remember, and importantly, to recall its roots. There can be no Caribbean pine trees without roots. Going deep into the earth, roots anchor, support, give life to, enable growth and development, and sustain trees. Roots go into trunks, into branches, into leaves, into flowers, into fruit. The roots of a written constitution do likewise. What are these roots? Well, these roots are the basic structure doctrine, which in other jurisprudence I have called basic deep structure of Caribbean constitution. There are other roots, but this is of significance. So when we want to talk about developing Caribbean constitutional jurisprudence, we cannot begin unless we pay some attention to this basic structure doctrine. How do we understand it? I'm using the analogy, the metaphor of a tree, because I think it's a good entry point. The text of the Constitution is like the tree that we see above the ground, as I've described. The basic deep structure is comparable to the roots, lying mostly, though not entirely, below the surface of the earth, and not always readily apparent, but in fact the constitutive superstructure out of which what we see and experience as tree emerges and is sustained. Indeed, I suggest that without this deep basic structure, these roots, the Constitution as we see it, and we are most often familiar with, would just simply fall apart, just as a tree cannot be sustained without roots. Some easy examples of what I'm trying to talk about. The doctrine of the separation of powers is part of the basic deep structure in Caribbean constitutionalism. Yet, nowhere in the actual Constitution is one going to see mention of separation of powers. Can't be seen, but it exists. Same applies to the independence of the judiciary. Not to be seen in the text, and of the rule of law. Although in the case of the rule of law, there are preambular clauses that mention it, and that's, we'll come to that a little bit also. But these three are good examples of the basic deep structure: separation of powers, independence of the judiciary, and the rule of law. Without them, what we understand and experience as liberal democratic states would not exist. And so they are integral, not just to creation of, but to the sustainability of sovereign democratic states. And you're going to see that idea of sovereignty in the written constitutions of the independent states and the references to democracy in all of our preambles. I suggest, as I have said, that these constitutional features are so fundamental that without them, Caribbean constitutionalism, understood as liberal democratic systems that we take for granted and expect, as I said, they would cease to exist. And so as we go forward a little more in depth, remember that I am placing these as part of the unseen, the roots, the basic deep structure of constitutionalism. And let us keep that in mind as we move on. This is maybe just for emphasis, so I won't dwell too much on it, but I just use the idea that this makes sense if we think about it as informing as these values and principles, like what flows from roots into a tree, inform the shape, design, and meaning of constitutions. I want to pause now, because this may be new for some of you, it may be provocative, and to allow for a moment or two of conversation. Anybody has anything they want to ask or say? I think there may be something in the chat. Is there, Larissa or Antonio, is there a comment or question in the chat? Or does anybody want to say anything?
No chat.
No. Anybody wants to ask anything about this? Is it new to you? Yeah. Who's going to at least say
I
something?
think a hand is up, Justice.
Yes.
Bonnie?
Hi.
Hello.
Hi, Judge. I
Hello,
think you're.
I'm Justice Patricia Farnese. I'm from. Am I on mute? Can you hear me?
No, we're hearing
I'm from.
you.
Okay, I'm a justice at the Court of High Court in Belize. Today is our Independence Day, so this
Yes,
is.
I know. Congratulations.
Thank you. It's a topic that's there, but I'm originally a Canadian, and I hear in your discussion this idea of the basic structure doctrine, and I think that there's some parallels with some of the interpretation in Canada. But am I correct to say? Well, maybe you don't want to say this, but I, having now become quite familiar with Caribbean jurisprudence and your court, the emphasis on human rights and the fundamental rights, that really is a unique jurisprudence. I don't think Canada necessarily, Australia, the other colonial Commonwealth nations have really clung on to that that birth out of, as you say, that birth out of those real injustices, although we do have that history to a certain extent. So I just was wondering if that's your perspective as well, that it's a real gap in those other jurisdictions to not connect to this.
Yeah, thank you. That's very excellent question, and of course, part of it is a comment. And so the Canadian jurisprudence, I think, does pay great regard to human rights, right, and to international obligations in the interpretation of what it does. So that I would, in fact, we draw on Canadian jurisprudence. Is it RDS celebrated, I think, 50 years anniversary? Well, I think it was this year or last year. And, you know, it's a seminal Canadian decision, but it has its roots in this sense of a deeper sense of justice, right? So I think there are parallels. I'm not as familiar with the development in Australia. I wouldn't want to speak authoritatively about it. But I do believe that what the CCJ is doing is really wrestling with the historical context of Caribbean people and trying to bearing that in mind, trying to give effect to fundamental rights. And I think that kind of contextual approach is, for example, seen in South Africa and India, in which, in both South Africa and India, constitutional principles of liberty and so on, and across the board, but the way they approach them has been informed by their socio-legal and historical contexts. And I think that is what I will come to as we go along is unique about what the CCJ is doing. But I think absolutely relevant in the Caribbean. Yeah, and I think that's why the article that I started with from the Commonwealth Lawyers News raises the point, as we'll come to. And that's why I kind of drew the parallel that in 1964 in the UK, well, there's this concern for human rights, and so the death penalty, mandatory death penalty, is abolished, right? But in 1966, the independence constitutions are introduced, but you have a Savings Law clause that still plagues the jurisprudence going to the Judicial Committee, where mandatory death penalty is considered constitutional for different reasons. So yeah, so thank you very much for that. Okay,
Thank you. I would acknowledge the Laird DPP who has a question as well.
yes.
Thank you, Justice Jamada. So far, you indicated it was going to be provocative. It's already provocative and very insightful, I must say. And I know you've not finished, but at this point, I'm getting a deep sense of the word you used, the Caribbean Court of Justice actually wrestling with the social and legal context under which the law is being administered and against the colonial history of the Caribbean people. Quite a bit of struggle there. And as a result of that, from what you have said so far, quite, again, eye-opening. I'm wondering why there is a struggle within the political directorate of the Caribbean people on making CCJ their last court of instance. I mean, last court of appeal, if you like. And I know you've not finished, but this is quite eye-opening, and I'm wondering why the struggle to get the independent Caribbean countries sign up to CCJ as their last court.
Well, I must say that I share with you your wonderment, but today's talk is not a talk to explore that. So I'm not going. I think it's a very important and interesting conversation, but I don't want to address it and get away from what I've been asked to do. But yes, thank you very much for that. So, all right, so let's press on a little bit. What I'm going to do now is I'm just going to share a kind of a summary of some key things, and part of it is going to answer what Eugene raised. So if we're going to talk about developing Caribbean constitutional jurisprudence, I want to identify some sort of overarching thoughts. 1, 2, 3. 1, where do we begin? Where do we begin? You know, if you have to tell a story, what do you say? Where do you start? You start at the very beginning, once upon a time. So we must begin with Caribbean realities, situational and contextual consideration. Historical, sociological, economic, and developmental. Very important. 2, all of the independent constitutions, people focus a lot on the supremacy clauses, which is important, but built into that is Trinidad and Tobago, Jamaica, Belize is a sovereign democratic state. We must recognize, realize, and reclaim Caribbean sovereignty by socio-historical and legal considerations. The next 2 are important, and I say unavoidable. Post and anti-colonial approaches to hermeneutics by understanding the power dynamics of status quo and of precedent. Now, this may be even more provocative, but whose interests are the law? Is the law designed to serve and protect in terms of power? And if that is a lens at which we understand law, then we have to recognize that colonial laws, the intention and purpose from a power dynamic was to serve a certain interest. And a critique has to be, is that still in the best interests of so-called independent and developing Caribbean states, where freedom, independence is independence from slavery and indentureship, from genocide. Freedom means something here. Is it possible? What new legal methodology, and we're going to come to that in terms of statutory interpretation, do we have to imagine and deploy if we are going to recognize, realize, reclaim Caribbean sovereignty and appreciate that post and anti-colonial approaches are necessary as methodology and to understand power dynamics of status quo and of precedent. A precedent is inherently a decision of the past. And the third big point is we need to take a holistic, right-centric approach. And we need to recognize constitutional supremacy, a hierarchy of constitutional values. I'll talk about that more in depth. Democratic development, which is why we became independent in the first place, and the privileging of human rights. So, Eugene, you asked a little bit, and in a way, your question was a good segue into this. And so I hope some of this begins to address what I think your little preambular comment was before you asked me about why isn't everybody coming to the CCJ. I'm not too interested in that today, but I'm much more interested in your narrative that led to that question. And I hope this is beginning to pique your interest at least, and maybe provoke you a little bit more, but that's okay. So let's press on. All right, some general principles. Constitutional interpretation, we have to start with, I'm going to suggest 4 big principles: special nature and character of constitutions, inclusive and all-encompassing approaches, holistic and evolutionary approaches, and chiastic approaches. Some of this is not going to make sense completely right now, but I hope as we go along it will. If we're going to do constitutional interpretation, I want to suggest that there are 5 basic questions. What is the purpose and function of a constitution? When you hear these questions, they should be self-evident. How should a constitution be interpreted? What guides evolving understandings of constitutionalism? How to resolve inter and intra ambiguities within a constitution itself? Because a constitution is not, there are contradictions in it, and intra-textual ambiguities as between constitution and other texts, other statutes. And what are the interpretive tools? What I'm going to suggest as we go along is that CCJ is addressing all of these questions in its jurisprudence, including the last question, and providing unique methodologies for interpretation that can help liberate us in the quest of anti-colonial freedom, the movement to freedom through anti-colonial methodologies. 5 basic approaches: have regard for basic deep structure, that's the roots of the tree, we spoke about that, preambles, and discern the fundamental ethos and values of a constitution. That's coming back to where we situated. Regard a constitution as encompassing hierarchical and intersecting norms, values, principles, and apply an organic intertextual approaches. Now, this is very important because this is actually the key that opens the door as to one of the big differences between the CCJ and the Privy Council. This idea of a constitution having hierarchical and intersecting values and norms and principles. 3 builds on that. Distinguish between major and minor features of a constitution and interpret and apply, do your interpretation and application. In Trinidad, we have a game called All Fours, as we say, trump and follow suit. You know, this follows, the activity of interpretation and application follows upon distinguishing between major and minor features of a constitution. Just a quick aperitif, as it were, so that if you have fundamental human rights, which are put front and center of your constitution, and you have a Sabin's Law clause, but it's in the constitution, is one major, is one minor. For those of us who know and love music, major and minor chords, you know, so in a sense, distinguish between them, and let those distinctions aid us in our interpretation. 4, prioritize the basic view structure because they are both integral, informing, and constitutive. Rule of law, human rights, and align what we do with subscribe to international values. And I'll show you how the CCJ has done that through the device of legitimate expectation. But our states are saying, oh, we sign up to these treaties. We say to the world, we sign up to the treaties. We do not have, if an international treaty is not incorporated in domestic law, we say it's not a law. But we say to the world, we represent to the world and to our people, this is what we're doing. And the CCJ is using the device of the principle of legitimate expectation to say, well, that has to resonate in the work we do, constitutional interpretation, etc. And 5, have regard to the collective wisdom of judicial decisions from a range of jurisdictions. The first question from Canada, Australia, South Africa, India, and of course from the UK. And very importantly, I think, to consider academic and other commentaries, because it's very important to read what the academics are writing, especially in developing societies where we are still in the early phase of this independence movement. And I say other commentaries because we need to read about what is the status of women and children? What is the status of affairs sociologically in terms of approaches to maybe people in the LGBTQI community, persons with disabilities. We need to understand that. Gender-based violence. We need to understand what is happening, and other commentaries from sociologists and so can help us in the interpretation and application of Constitution. All right, so that is an overview, and I think it's sort of priming you for where we want to go to next, which is to do a little bit more of a deep dive. To get into there, I just want to, just give me 1 second, I just want to check something on my parallel screen to make sure that I am not going off track. Okay, good, right, so I am. So this deep dive is to try and get into the CCJ's jurisprudence a little bit more. Some of it I'm going to dwell on, some of it I have too many slides I'm going to pass over a little bit quickly, but I'm going to just try and see how we go. I have one eye on time. On my left-hand side, I have my stopwatch that is running because I know how much time we have. And then I have on one side a certain screen with certain stuff up. So, I'm going to be a little bit fluid in what we do, because I do want to allow for some conversation, but I also want to try and cover the important stuff. Special nature and character of Caribbean constitutions impacts methodology. So here are 4 big movements, and we're going to do this in more depth in a little while. Caribbean constitutions are sui generis. They have their own interpretive principles. Those must take paramountcy, and therefore, the interpretation of Caribbean constitutions is a legal activity in its own right. With that in mind, I want to move to a very seminal case of the CCJ, the case of McEwan and others, and the Attorney General of Guyana. It's a 2018 case. And in a moment, I'm going to ask Larissa to share with us the sort of narrative about the case. But before we do that, I want to talk to you about something called hold-ons. Anybody or everybody knows what Russian dolls are? That's the image of Russian dolls. It's part of the Eastern Orthodox tradition in which you have identical, they don't have to be identical, but often identical little dolls, and they are miniature and they fit into each other. What is a hold-on? A hold-on is actually a principle coming out of science, and it is the idea that the universe is fundamentally made up of holes within holes within holes, holes and parts, all the way up and all the way down. So at the very tiniest level, subnuclear level, you have stuff that's going on that is in everything that comes up. And actually, these holes within parts within parts within holes is what makes the universe what it is. So this idea of hold-ons is very integral to reality. The CCJ in McEwan says, and this is what the commentary says about it. This is a holistic approach. The Constitution must be read as a whole. Court should be astute to avoid hindrances from interpreting the Constitution in a manner that is faithful to its essence and its underlying spirit. If one part of a Constitution runs up against an individual human right in another part, then you must interpret it as a whole and place a premium on the enjoyment of fundamental rights. So the idea being that you have this holistic approach suggests that within a constitution, there are principles that are within and a part of everything. And when we interpret constitutions, we have to take this holistic approach. I'm going to invite Larissa, because it's good for you to hear from a different voice. You get bored of seeing and hearing from me all the time, to share with us a little bit about McEwan, to give us a little factual sense of what the case was about. Larissa?
Good morning, all protocols observed. The case of McEwan is an appeal emanating from Guyana. It's concerning transgender persons cross-dressing in public. The first two appellants were awaiting transport. McEwan was dressed in a pink shirt and a pair of tights along with a black hairpiece. And Clark, the second appellant, was wearing slippers, a jersey, and a skirt. A party of police officers passed by them and arrested them. Now, the last two appellants were dressed in a skirt and wore a wig. They were attacked while having a meal and they were forced to flee for their safety. Later, they were arrested. All four appellants were charged with the offense of loitering and wearing female attire in a public place for an improper purpose, contrary to the Summary of Jurisdiction Offences Act. The appellants pleaded guilty and were sentenced. The appellants then brought a constitutional challenge, arguing that the section violated their constitutional rights to equality, non-discrimination, and freedom of expression. They also argued that the law was vague, as there was no indication as to what would constitute male and female attire or what would constitute improper purpose. At the High Court, the trial judge held that the law was saved, it was an existing law, and therefore it was immune from constitutional challenge. And they did not agree with the appellants that the law was vague. This was the same thing that was held in the Court of Appeal. The law was saved and it was immune from constitutional challenge. The CCJ agreed with the appellants that their rights had been violated. So the CCJ basically held that section 153(1)47 of the Summary Jurisdiction Offences Act was not immune from judicial scrutiny just because it was a pre-independence law. The section violated the first four appellants' rights to equality, their right to freedom of expression, and also that the section offended the rule of law as it was vague. The CCJ therefore ordered that the section be struck out from the laws of Guyana. Very interestingly, 2 days before the judgment was delivered, 2 days before the hearing, the judgment was delivered in the case of Nerve and the Queen and Severin and the Queen. This is basically a Barbados case dealing with the mandatory death penalty. And again, this issue of the savings law clause arose. And the CCJ basically stated in the judgment at paragraph 59, with these general saving clauses, colonial laws are caught in a time warp, continuing to exist in their primeval form, immune to the evolving understandings and effects of applicable fundamental rights. This cannot be the meaning to be ascribed to that provision, as it would forever frustrate the basic underlying principles that the Constitution is a supreme law and that the judiciary is independent. This hallowed concept of constitutional supremacy is severely undermined by the notion that a court should be precluded from finding any pre-independence law, indeed any law, to be inconsistent with a fundamental human right.
Thank you very much, Larissa. So that gives you a sense of what happened in McEwan. And as you can see in McEwan, what is happening is that they are talking about evolving understandings and effects. And you can see that they are working with the idea that you cannot frustrate principles in a constitution where the constitution is the supreme law. But how is this achieved? In McEwan, it's achieved because the fundamental rights are given, which was what was decided in Newey, priority over the Savings Law Clause. So even though they were both in the Constitution, there are hierarchy of values, and the higher value, as it were, is the human right value. And so that the Savings Law Clause has to be read in that context, and as it were, read down to the degree that you can uphold the Savings Law Clause. But it's also coming out, if you read this, what's up on your screen, colonial laws are caught in a time war, seemingly immune from evolving understandings and effects. Now, remember in 1964 in the UK, they passed laws saying that, look, the mandatory death penalty would now become, would no longer exist. That was never done in the Caribbean. And so you still have the mandatory death penalty. And the CCJ is trying to find a way to say, no, the fundamental rights at the heart of the Constitution have to be valued, have to be given effect to. And so McEwan, not in the case of the death penalty, but in the case of a law that was discriminatory in relation to cross-dressing, what was called improper conduct, was equally unconstitutional, as Larissa has explained. The court says that the court should be able to find not simply a pre-independence law, but any law, if it is inconsistent with the fundamental human right, to find that and to find an effective remedy. The next case we want to look at is the case of Marin. This is a more recent case, it's 2021. And what the court has tried to do in Marin is to meld what I spoke to you about earlier about the sui generis center and certain approaches. I'm going to develop this more as we look at Marin, to give voice to a more inclusive and encompassing model of constitutional interpretation, to prioritize substance over form, and to do so in a way that recognizes and places at the center of the hermeneutical exercise, that is the method of interpretation, the sui generis nature of constitutional interpretation. Remember we said it's an activity in its own right. The document is a document that stands on its own. It's sui generis. And so the CCJ is putting that at the heart of what it's going to do. And in doing that, it's developing a methodology, a hermeneutic that allows the court, following completely legitimate legal approaches, but creating a methodology that allows the court to uphold the aspiration of Caribbean peoples when they said in their written constitutions, human rights values are salient, significant, and to be prioritized. So Larissa will just summarize for us a little bit of the facts in Marin, and then we move on.
Sure, Judge. Solomon Marin Jr. was tried by a jury and convicted of the crimes of kidnapping and robbery. He was sentenced to 2 concurrent 10-year terms. Marin appealed the conviction and sentences imposed, and there was a 9-year delay between his conviction in the Supreme Court and the hearing and determination of his appeal. Marin withdrew his appeal against sentence, but maintained his appeal against conviction. On appeal, Marin argued that the post-conviction delay breached his rights to a fair hearing with a reasonable time. He asked for his conviction to be quashed. The state admitted that the delay breached Marin's fundamental right to a fair hearing within a reasonable time, but they argued that the conviction did not need to be quashed as it was otherwise sound. The Court of Appeal proceeded arguendo on the basis that Marin's right to a fair hearing was within a reasonable time was breached, but they refused to quash his conviction, finding that it was otherwise sound. The Court of Appeal did not grant Marin a remedy for the breach of his fundamental right. So the CCJ upheld this appeal, and before the court, the state argued a preliminary point, essentially saying that that Marion ought to have brought an originating application and they could not raise this issue in the hearing. And the CCJ found that the Court of Appeal can, in certain circumstances, grant relief and a remedy for a breach of an individual's fundamental rights, where the breach arises during a case before it, even if it is not directly related to the issues that may or do arise in the substantive criminal trial. In such instances, there's no necessity for an aggrieved individual to seek such relief by way of a separate originating application. Marion was essentially granted his relief for breach of his constitutional right to a fair hearing within a reasonable time. The court granted both a declaration and an order suspending any further execution of the sentences imposed.
So what's happening in Marion? In Marion, we are seeing this idea of an evolving understanding and effects. Caribbean constitutional interpretation, court says, remains an unfolding, forever unfinished process. What is a process? A process of reflection, discovery, assimilation, refinement, and application. One of the things about the CCJ is in the agreement creating the CCJ, there is a mandate. And that mandate is to play a determinative role in the further development of Caribbean jurisprudence. So the CCJ has actually been tasked in its document of origin to develop a Caribbean jurisprudence. In this mandate, the court's role is intended to be transformative of both law and society. So just to place you in a sort of a contextual way, that and to say that the CCJ is a court that has as its purpose, its intent, a court to develop a Caribbean jurisprudence that is relevant, suitable, but also transformative of the society in which the court is functioning. I'm going to submit to you that prior to what the CCJ embarked upon in its constitutional jurisprudence, what has been happening is that there has been constitutional interpretation on the circumference of the circle. I'm using the wheel there as an image and as a metaphor to try and make the point. And what the CCJ has done is not be limited to deciding cases along the circumference of the wheel. It has gone to the center, the sui generis nature, and effected approaches that take place from the center, and having done that, they radiate out through the spokes of the wheel to every aspect. You remember what Marion said, what they said in McEwan? Not just different parts of the Constitution, but any law that is inconsistent. And what I'm going to try and demonstrate to you is by placing its approach at the center and adopting a methodology that works from the center outwards, it is affecting all law, all executive action within the context of constitutional supremacy and the independent Caribbean states. So what has begun to emerge is a chiastic jurisprudence, that is to say, it's coming out of a resonant chiastic epicenter, meaning it's moving outwards in these ripple effects, if you want to call it that. It is inclusive and encompassing as a method, and it is a flow towards greater symmetry and a balancing of all parts, keeping your imagination the wheel. And it is a movement towards a more unified and interpretative whole. What is the center point? Spoke about it already, the sui generis nature of the Constitution. And so that becomes the primary lens through which you must read, interpret, and apply constitutional provisions, values, and principles. This center point facilitates the search for meaning. So when we talk about what is the intention, what is the meaning of the Constitution of a statute, What the CCJ is saying is, when you understand what the sui generis center point is, that facilitates the search for meaning, both within the Constitution and for all other laws. 4 basic movements. I'm going to do a summary of what is happening in Marin. I think it may be helpful to you. There are 4 basic movements that are taking place in Marin. First of all, begin with a recognition of the origin and character of the instrument. Recognize, this is fundamental. I think this is what Eugene was asking about. It is grounded in a regional and local Sitzenleben. Sitzenleben means the life setting, the life context. And that includes legal customs, traditions, conventions, culture, and history. That is where it is rooted. And if you don't understand that that is where it is rooted, then you're not going to get the methodology right. Every plant is rooted in something. Every life is rooted in something. Every society is rooted in something. And one of the questions that we have to ask, and why keep the Privy Council, why not go to the CCJ, comes down to this idea of rootedness. You know, if you eat mangoes from India, or from Malaysia, or from the Caribbean, or from Israel, they all taste different. They're rooted in different soil. They're rooted in different soil. It is an approach in which the movement reaches backwards and forwards. So it can reach all the way back, pre-independence laws, and transform, do something with those laws, as it will stretch forward into the future with these values and principles. It is informed by unique ideological interpretive approaches. Now, we may be very concerned about that word. What does law have to do with ideology? Well, maybe provocative. Law has everything to do with ideology. What is, and that is why I spoke about earlier about anti and post-colonial approaches. Gender-sensitive approaches are part of an ideological interpretive approach to law. So if we talk about equality as a fundamental human right in a constitution, and if equality means we need to pay attention to gender-sensitive adjudication, what do we do with laws that were forged and formed in a patriarchal context, and that by their very nature, yes, precedents say this is what they mean, but viewed now through these more progressive, maybe more liberal democratic values, we see gaps. And so that is why one of the movements is a movement that is informed by ideological interpretive approaches. 7 such approaches we suggest at the CCJ. This is all in Marin. This is all the jurisprudence of the CCJ. Guided by principles giving full recognition to fundamental human rights and freedom. That is an ideological approach. The ideology is an ideology that puts human rights at the front and center of the interpretive process. It is open-minded, not closed-minded. It is generous, broad, and purposive. It treats the Constitution as a living instrument capable of responding to evolving societal attitudes and norms, not stuck in a pre-independence era that is archaic and arcane. It is present and future-facing, i.e., it is democratically justifiable and consciously and independently developmental. Laws must facilitate the development of a society. In the Caribbean, the first so-called first world countries describe us as developing societies. Well, okay, then we must take that on and use the Constitution and use it ideologically as a developmental, an instrument of law for the development of our societies. I won't dwell on that. Marin gives us 8 aids to interpretation. We spoke about the sui generis center. Well, these are more traditional aids, and these will maybe resonate a little more comfortably with you. What is the language of the text? What are the surrounding circumstances? What is the discoverable intent? What is constitutional common law? What are the core and basic deep structure influences? What are relevant international values, principles, and conventions? What are local, regional, and comparative international precedents? And of course, the corpus of relevant academic and research literature. So these are the tools that Marion says you can use as aids. Professor Simeon McIntosh talks about integrity as an adjudicative principle. He's an academic, writing. Let's take him seriously. Caribbean person. Integrity as an adjudicated principle. What is the principle of integrity? Well, first of all, the word integrity, from Latin integer, it means whole or intact, literally untouched. And so an approach, if we are going to use integrity as a hermeneutical method, then that is speaking about an approach that recommends seeing and interpreting the Constitution as a coherent text. It is interpreting it in a way that makes it as just as it possibly can. That is a holistic approach. And therefore, as an adjudicated principle, integrity requires that the various provisions of the Constitution be read as expressing a coherent scheme of justice and fairness. That is going to beg the question, how can you in one breath say the mandatory death penalty is cruel and inhumane, and at the same breath say, but constitutional? There's no coherence in that. That is inherently incoherent. It lacks integrity. And so integrity as a method of statutory, of constitutional interpretation and principle demands that we find a way to achieve coherence. And that is how the CCJ comes up with the idea of a hierarchy of values and major and minor themes or tones, principles in a constitution. All right, that's another bit that we've done with a lot of stuff going on. So let's take another pause for an opportunity for you to ask something or say something for clarification or comment. Anybody? If nobody speaks, I'm going to be concerned because this wouldn't just be, I just want to make sure that you're all still, good, somebody. Yes? Hi, Judge.
Sorry, it's not my training. I'm just an interloper, but I'm really interested about the, and I struggle with this because when we put human rights at the front, the fundamental rights, they're individual fundamental rights. And when I talk to my Indigenous colleagues, especially in Canada, they say, you know, sometimes our values are community-based and the individual yields to the community. And so when we're, which I love, the idea of rooting into the place, what do we do with that tension?
Mm-hmm. No, that's an excellent question. And it's one of the gaps. So, I mean, my take on that is this. And in a different place and space, I speak about that, right? The history of the individual fundamental rights comes at 1948, Universal Declaration. It's coming out of World War II. It's also coming psychologically on the heels of Jung and Freud and a preoccupation with the individual. It's also coming out of a colonial world, right? Where the idea of empire is not rooted in the equality or of all of the respect and even though Article 1 says all human beings have equal in rights and dignity, right? The reality is these individual human rights are shaped by a northern Western psychology and view of law in which the individual is at the center, right? That whole rights movement did not arise out of an indigenous center or Aboriginal center, in which clearly, certainly in Canada, as you well know, The big critique is that. The big critique is there is no individual. An individual does not exist outside of the context of a community. And so the only rights we can talk about is community rights. And that community actually also includes the environment, ecology. So these are two totally different mindsets. It challenges the Western mindset is trying to fit this totally different model into a box, into a container that cannot accommodate it. And so in a different talk, I did a talk at the University of Toronto, and to the university, to the academics there, and I said, you know, what happened in 1948? I think we need a new moment in which this idea of a universal declaration of individual human rights, we need to come to a universal declaration of the rights of people's community and the cosmos. Because that movement has exhausted itself. It can no longer carry us into a notion of individual rights, right? Interestingly, in Guyana, for example, the Constitution of Guyana has provisions which are closer aligned in their revised constitution to indigenous peoples' notions of community, the land, and so on. But so it's a very good question. I don't think, I think the project that we're all trying to do, which is to fit it into, is doomed to fail. It needs a rework. I mean, who is a person? What is a person? Right? So, I mean, these are fundamental questions. Does a person include an animal? What is personhood? What does it mean to be person? Is person an individual, or is person, is there a difference between individual and personhood? These are fundamental questions of philosophy and thought that have not yet been able to penetrate into the mainstream of Western legal thought, right? So I think excellent point. I don't know that we in the Caribbean are anywhere close to what you and I are talking about now in terms of creating a jurisprudence that accommodates that degree of communal privilege in terms of rights, right? But yeah, I think that's why we have to see it as evolving and unfolding. Because if you take the pulse of the world right now, that is where we're moving to, right? That's where we're moving to. And in a sense, I think, this is my own personal view, I think the project launched in 1948 in a big way of individual human rights has taken us as far as it can go. It's time for a rewrite, because it can't take us any further. It's done. It's served its purpose. It's not to be thrown away, but it's to be assimilated and incorporated into something which has a broader, wider vision of what it means to be human in this world, in this cosmos, what it means to be a person versus an individual, and what it means to be part of an environment that we now know is not separate and distinct. You can't cut it up, right? And I mean, the fires in Europe, in Canada, in the Western provinces, in the States, in the Caribbean, heat waves that affect us, rising tides, you know, so we need to do a rethink. That's a little beyond the scope of what we're talking about today, but thank you for the question. I don't know if that helps you at all, but all right. So I think what we can do, it's 12:09. Yeah, Eugene, you have a hand raised?
Yeah.
George, I don't know whether you have time for this. Otherwise, we can move on. I don't want to preempt you again. Do you give me the liberty to make a comment, quick one?
Sure, of course.
All right. Parliamentary supremacy over the Constitution, and then supremacy of the Constitution in the Caribbean, overseas territories and their constitution, and yet they are Caribbean people. Where does this leave a judicial officer who will be struggling with the clash that I am sensing, which is real one, and is positively radical and transformative because you are dealing with the community at the end of the day, irrespective of their, geopolitical and social history and legal history. But at the bottom line is they are real people in real geographical location called Caribbean. How does a jurist grapple with this?
Yeah, no, it's a struggle, right, Eugene? I mean, and there's no way around that. I'm going to share with you in a little while, actually. I mean, how the CCJ has tried to do it. We'll talk about a case called the Maya Alliance case. So I don't want to preempt that. We're going to come to that in a minute. What I do think, however, is that we've been going for about an hour, well, actually an hour and 10 minutes. And so I think that I'm just going to put my stopwatch on. I keep it with me all the time. I'm going to put it on. Let's take a 5-minute stretch break. Just to allow you to just stretch a little bit. Some of you want to check your WhatsApp messages, other social media stuff. Do it now, and then we'll come back. Well, 12 seconds have gone in 4 minutes and about 70 seconds. So see you in a bit.
Thank you, Justice Jawad.
back to everybody. I hope that you did get, maybe some of you were able to just get some coffee or, you know, a little bathroom break maybe, but I hope you're all back with us. One of the challenges with the virtual world is that it's very difficult for me to gauge, you know, how many of you are multitasking, or how many of you are paying attention, or how many of you are even engaged. But I hope you are engaged, and I hope that this is having some value for you anyway. So we have we can spend we have another 45 minutes together about. And what I'm going to do is I'm going to make a little shift in what we're going to do just to get through what we want to get through. And yeah, we'll press on. So, but before we do that, Larissa, you said someone had a hand raised that I didn't.
I saw Justice Jackson had a hand raised, and
Okay.
I'm not sure if Judge wants to still make that comment or ask that question.
Yeah, hi. Judge, did you want to say something? Apologies if we didn't pick it up.
Good afternoon, everyone. Justice Jamadar. Just a quick comment that I have been enjoying the historic journey and also enjoying the analogy of the Constitution as a living organism, like a tree with old roots that can bear new fruits, which are sensitive to the needs of human rights, for example, rather than the traditional view of the Constitution as something set in stone. Everything that come up against it would be crushed and destroyed. So I am embracing this analogy, and I'm enjoying the journey that you have taken us on this afternoon, this morning.
Go. Thank you very much. Good. Well, let's continue on the journey then. Let me just get this here. All right. There we go. This should work now. All right. All right. So what I want to shift to a little bit is, and I'm going to go a little quickly through this. Larissa and I had planned something slightly different, but I'm just going to go a little quickly because I think that from what I'm sensing, this may work a little better, maybe a little more effective. What are the consequences of what I've tried to describe, right? What are the consequences of this? Putting everything, the sui generis center, working from the inside out. You remember I gave you the analogy of the wheel earlier? And this is actually a fusion explosion, right? And so you can see the circumference of the wheel, but what I'm trying, so the visual I'm trying to give to you is to make this point. When you shift the process to the center and you explode it there, the impact, you can't, and this is a scary thing in law for jurists and attorneys and governments, but you really cannot control the spread because it's going to spread from the center out. So historically, jurists have been much more prepared to work on this circumference and do a little bit here, a little bit there, a little bit there, a little bit there. In my understanding of the work that the CCJ has done and is doing, they brought it to the center. And where does it end? We don't know, I suppose. But what I believe is, and what I am seeing, and I'm going to try and show is, that because it's at the center, it is radiating out from the center and impacting, and I'm going to demonstrate that, I hope, several different areas. So let's try and go a little bit quickly. Rule of law and protection of the law. The CCJ has done this, taken this bold step, and as you're going to see, different from the Privy Council. Chandler talks about that. Constitutional norms that can be independently enforced, part of the basic deep structure, I touched on that, and therefore they are overarching norms that are fundamental to Caribbean constitutionalism. And there are a slew of cases starting in 2006, court came into being in 2005 in Joseph and Boyce and Lucas, Nerve, Maya Alliance, McEwan, and so on. In Maya Alliance, the Maya people alleged that their land rights were not being protected. There were no laws dealing with this. They come to the CCJ, and the CCJ determines, hold on, you know, the principle of the protection of the law is a constitutional law, part of the basic deep structure, overarching and fundamental. And a state like Belize cannot say there is no law saying that the Mayas people have land rights, so they have no land rights. No, the protection of the law in appropriate cases requires a state to take positive action to secure and ensure the enjoyment of basic constitutional rights. In other words, the state should have historically and now must take steps to protect the Maya people's right to land holdings. Now, of course, it's a little more complex than that. They look into the preamble where they acknowledge the Maya indigenous people and so on and so on. But the fundamental move is to take the principle of the protection law and say that it puts a responsibility on states to ensure that there should have been and there must be land laws to secure these people's rights. They just can't exist in a vacuum and say you have no rights because there's no law for it. And that's a radical move. What becomes a normative and authoritative is not the letter of the text or the absence of a letter in that case, but the basic deep structure that underpins, informs, and constitutes, is constitutive of the text as a constitution. So Maya Alliance, let's just go back a little bit. Maya Alliance is a good example of that. What about state contracts? Case came to us, Belize International Services, Belizean case, about a contract between the state and somebody about ports, creation of a registry for ports and so on. And the majority of the judges, the court decided the case on contract law, but majority of the judges also decided that, you know something, the state is obliged under the Constitution to treat with contracting parties in accordance with the rule of law. Remember what I said about the rule of law and protection of law as sort of ground norm principles, fundamental principles. And part of the rule of law is the principle of good governance. Court extracts that principle. And therefore, the good governance, which the court says is down-to-earth fairness and reasonableness. And so in contract law, the duty of this government implies treating with contracting parties fairly, honestly, openly, in short, in good faith. So remember the idea of bringing it to the center and how it has effects? Well, here it is in a state contract. Yes, you can decide the case on contract law. But you also need to look at the case and ask, if the state is entering into a contract, then what are the implications of constitutional values for that? And the court says, well, good governance, rule of law, good governance, good faith, in this case, found there was a breach of good faith, and then certain remedies followed. The executive and all state and public agencies and authorities are subject to the standards of accountability and good governance in all of their dealings with private enterprise, including with private enterprise third parties, including in the making, changing, and breaking of commercial contracts. So whereas the normal approach may have been to say, well, okay, this is a case in contract, and we apply all the principles of contract. No, court is going further and applying this approach. If laws passed by the legislator can be struck down as unconstitutional, so can state actions. General statutory interpretation. So now let's move to the implications for this approach, not just to the interpretation of the Constitution, which, as we said in both in Newvey and McEwan, you're looking at this hierarchy of values, and you're saying you are going to privilege or prioritize human right values. So if human right values come up against a savings law clause in the Constitution, well, hold on, you have to find a way to privilege the human rights, hierarchy of values, and so you read down the savings law clause and you privilege the human rights. Rule of law and protection of the law, these are enforceable in relation, if you remember in McEwan, the rule of law principle therefore said that a vague law, no, laws can't be vague. And so struck down. Protection of the law, my alliance. You must make sure there are laws to protect these, to create and protect these people's rights to land. Constitution, the preamble talks about these peoples. There are no laws governing them. You have a duty to do that. At the center, radiating. How does it affect every single statute? Courts faced with a choice as to multiple interpretation of statute provisions need an orienting filter. This is A.J. and Thomas, a Guyanese case. One such filter which demands priority is the deep basic structure and core constitutional values. So right now you see what's happening. On the circumference, every single statute that exists in the corpus of laws, one choice where there are multiple interpretations that demands priority is looking through the lens of constitutionalism. It is critical to interrogate assumed and inherited legal methodologies taken as givens and seek to discover new ways of seeing, interpreting, and applying the law. And this is, to my mind, really what is the creative work of the court. Because we all went to law school and all the faculty of law and studied law, and we are told, you know, follow precedent, you argue in legal argumentation, follow some set patterns and so on. But where is the methodology for a society that has suffered what it has suffered under a colonial regime that has left its corpus of laws as the laws of that state, but that now has a constitution that is supreme and does certain things? When you have to come up with a post-colonial, anti-colonial methodology, otherwise you're always going to be caught in a time warp. And that's what Nerve is saying. One of the things you have to do is you also have to critique assumed and inherited legal methodology. And this is work for not just academic, this is the work, it is actually the real work that we as Caribbean jurists have to do to discover new ways, new methodologies. And I think that's what the CCJ is doing. In this way, we can bridge the gap between the law as written and current, new and emerging social realities. And I'm suggesting that this is, well, the case in Thomas is saying that this is not judicial overreach. Oh, activism. It's not activism. It's judicial duty, which is constitutionally warranted, because that is what the court is supposed to be doing. Faced with multiple different choices, choose the approaches that most align with relevant and applicable constitutional deep structure values, human rights principles, and international obligations and standards. A slew of CCJ cases saying that. In Thomas, the court put it this way: a hermeneutic of constitutionally grounded open inclusivity. That's a mouthful. A way of interpreting, a way of analyzing that is grounded in the Constitution, that is open-ended, that sees, interprets, and applies the both-and parliamentary intent and aligns more readily with constitutionalism. So what does that mean? When you are doing the task of interpretation, it's not an either-or. You don't say, okay, this is what the law says, and I must give literal, golden rule, purposive. It's not an either-or. It's a both and. You need to do that, but you also need to do both that and the critical constitutional analysis. Why? Because in these independent states, all of them have the supremacy principle, which says if a law is inconsistent with the Constitution, it is void. We'll come to modification in a little while in Barbados, but you need to do it. So you cannot say this is let me come to it. I think we come to it somewhere. The court pointed out that in constitutional democracies function under the rule of law in the context of constitutional supremacy. Court should interpret legislation not only to achieve the objectives of the legislation and the intention of Parliament. This is radical, but to achieve alignment with fundamental human rights, etc., including your international obligations. We're going to look at this case of O&O. I'm going to tell you about that in a minute. So you don't just look at the law in a box. Yes, you look at the law in a box. You do that. You just try to discover the meaning of the law in a box, but you also have to pass it through the filter and lens of constitutionalism. So in O&O, Barbados case, domestic violence, the female partner is abused, had lived with the person, was in a relationship, separated, has a child, comes to court for protection. The magistrate asks the person treating questions, one of which is, the law says that if you are a spouse or former spouse, you are protected. Ask the person, are you a spouse or former spouse? Person says, you must be mad. I have nothing to do with this person anymore. Magistrate said, okay, but if you're not a former spouse, you're not protected, no protection. Court of Appeals looks at it and says the magistrate was entitled to ask the person, and if the person said they were not, well, tough cookies, I guess. Came to us. But first of all, we said, well, this is a question of law. It's not what the person says, whether they think they are spouse or former spouse. It's whether, as a question of evidence, they qualify. And a very interesting thing occurred, because in the Court of Appeal, and before, especially in the Court of Appeal, there was a struggle about former spouse, because in a relationship that is cohabitational, or even a visiting relationship, the Court of Appeal was asking, well, former can't be forever. There must be some sort of time constraints, and so on and so on. The advocate, maybe a little tongue-in-cheek, and maybe even a little bit provocatively, raised in the transcript with the Court of Appeal, well, is there a time limit on a former judge? If you're a judge and you stop being a judge, you're a former judge. You're a former judge forever. Why should it be different for a spouse? And basically what the CCJ says, it looks at the law, it looks at the human rights provisions of equality of treatment, and it looks at the international treaty that Barbados had signed into, and it says, listen, the fact of the matter is this law was intended to do two things: to protect victims of domestic violence. Domesticity includes all domestic relationships, and it includes, and it must be interpreted to include, spouses and former spouses included in visiting relationships. And in this case, they had a child. And once those requirements are satisfied, then there must be protection. What was amazing is, because of the decisions, the lower decisions in the court, what happened was the police were not even entertaining complaints, and the magistrates' courts were not even allowing victims of domestic violence or alleged victim survivors of domestic violence to bring complaints. And so the CCJ intervenes and says that this legislation needs to be interpreted. One way we must look at it is through these different lenses that I'm talking to you about, and overturned the earlier decisions. And so you can see right away that this approach to constitutionalism has impact for constitutional interpretation per se, but is also having interpretation for other legislation. In O&O, in Allen, I had said something about all statutory interpretations must include a consideration of whether the law as stated can be interpreted in a manner that is consistent with the Constitution. All legislation must be filtered through constitutional lenses, and therefore, where we've covered this ground, what I'll highlight here is, in a constitutional democracy where the Constitution and not Parliament is supreme, it is a constitutional imperative integral to the task of statutory interpretation, i.e., to put the Constitution at the center of statutory interpretation and not at the periphery, which is sort of what is happening with what was done in O&O. In O&O, the majority of the court, I didn't write the lead opinion, another judge did, actually Justice Rajnath Lee, and everyone agreed with her, endorses the approach. So this is the jurisprudence of the CCJ. CCJ talks about, in Bisram, another case, that in Barbados, modification first enables the Constitution by respecting and advancing its cherished ethos. It avoids the artificial conundrum that a law that plainly infringes fundamental rights must be held to be constitutional and valid. And so it's now saying, and we come to that in a little bit, because in O&O, the court builds a little bit on that and says that this duty to modify is demonstrative of a deeper constitutional principle of conformity. So you can see what's happening. Oh, okay, what's happening with conformity, which in its truest sense is the principle of statutory interpretation and application. In other words, what the court is constantly doing is developing a method of statutory interpretation in these cases, which is putting the Constitution at the center. In O&O and in Bishram, it's saying that, you know, this is demonstrative of a constitutional principle of conformity. In other words, every law must be read and analyzed to ensure it conforms with, it is consistent with these principles. Thus, in Barbados, the domestic violence legislation must be interpreted and applied so as to further the appellant's rights to liberty, security of the person, and the protection of the law, and to do so with equality and non-discrimination. So again, you see, the court has not been content to rest and say, well, okay, Domestic Violence Law Act, what does the act say? Let's interpret the act within the four. No, court has gone very much further to pass it through a constitutional lens, not in a peripheral way, but to put it at the center. Courts of Barbados, therefore, have a continued responsibility to ensure that statutes adhere to and are consistent with, so far as is appropriate, the core values, principles, and commitments contained in both the Constitution and ratified treaties. These approaches to statutory interpretation are not peripheral, but central and paramount. All right, TCI. When the Chief Justice asked me about this, she said, well, you know, yes, I want you to talk about what you all are doing in your court, because I think it is creative, but you know, in the TCI, well, we are an overseas territory, and so that could you at least do a little bit of comparative work so that it has some relevance for us, because otherwise it just could be exciting, stuff. Well, modification. In Roach, case that you probably know, this is a case, I think out of Bahamas, but it says here that the provisions of their constitution are supreme, as the constitution had a modification clause requiring existing laws to be modified or amended to bring them in line with the constitution. So because the constitution had a modification clause which required that existing laws be brought into line, in that sense, the constitution is supreme. So I'm bringing that to your attention because in section 5.1 of the TCI constitution order, we look at this section in a little while, there's a similar provision. So constitutions may thus be the highest law in the territory, but even though they do not supersede laws created by the UK to govern them within the territory, you can see that there can be a notion of supremacy. Which is quite fundamental, and in most instances is going to have quite a wide impact. And so section 5.1 of the TCI Constitutional Order 2011 says, subject to this section, existing laws in red shall be read and construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring them into conformity with the Constitution. So here you have a vehicle I suggest for you to at least think about that can allow you to do more or less what the CCJ has been doing, even though this jurisprudence has not been built out in your own jurisdiction. And of course, subject to the very clear point that the Constitution is not supreme in the same sense, in that the UK Parliament, through an order in council, can change both the Constitution and obviously any other law. So, big debate now in the AI world, right? Is AI art? Your thoughts? It's 12:40, and I want to pause for a minute to give you an opportunity to reflect on some of what we've just covered. A new voice, maybe, but if not, happy to hear a voice that has already spoken.
Justice Jamadar, I have a question.
Yes.
to what extent are the ideological approaches impacted by the nature or the type of the state? So in the Caribbean, we have the constitutional monarchies, you have the republics, and then you have the cooperative republic of Guyana. So to what extent, if any, does the type of state impact it?
Yeah, very good question, Antonio. Thank you. It does have a big impact. So, for example, the Corporate Republic of Guyana clearly founded, it explicitly states, is founded on socialist principles, right? And so that is an ideological policy. The state is saying in its preamble and so on, and in its non-directive statements, that this is an ideology. And so when we come to interpret and apply law, the Constitution and the law, that will be a unique influencing lens, right? Now, for example, in Trinidad and Tobago, it talks about the distribution of wealth for the benefit of all. It's not as overtly socialist as maybe the Corporate Republic, but actually that is a very socialist view, right? Or position. So there is a debate about directive and non-directive provisions in the Constitution. But I think, in my own view, that they are in the Constitution. The Constitution is supreme. The CCJ has said that preambles, we're going to come to that in a moment if I get the time to get there, I hope so. Preambles are an aid to interpretation and the application of the law. And so, yes, I think that even though there are some general overarching, which I have tried to cover, within that, to talk about ideological approaches is to recognize that every state and territory could have a unique ideology. So, for example, in the TCI, you cannot escape the ideology that it is a territory. That is ideological in the sense that independence is in a limited way, right? And that's part of what you have to factor in. You can't avoid it. So I think the answer to your very good question is yes. It should vary from territory to territory, depending on whether there are clear nuances that will shape the legal ideology, constitutional ideological approaches. Yeah, thank you.
Thank you.
Anybody else wants to ask anything or say anything? Okay. I'm sure that's not because you agree with everything I'm saying, but let's press on. What I want to do to end is just to give some very maybe kind of clear examples to try and make some points. And we're going to do it 4 areas: privilege of human rights, consistency with your international obligations, substantive protection of the rule of law, the protection of the law and rule of law, use of preambles, and basic deep structure. We've covered this already, so I'm going to go pretty quickly over this. In a way, the provision of human rights, we've covered this. I just have several slides, which in a sense now are repetitive, so you'll have them. I won't dwell on them. They're just pulling from the cases, you know, what I've said already. So I don't think I want to dwell too much. I'll dwell on 1 or 2 things. In Nirvana, the CCJ said at paragraph 58, I'm reading this because I think it's impactful. The General Savings Law Clause is an unacceptable diminution of the freedom of newly independent peoples who fought for that freedom with the unshakable faith in fundamental human rights. So here's the CCJ. I talk about Sitzen-Leben and ideological approaches and freedom and social context. Here's the CCJ being unapologetic, you know. The idea that even where a provision is inconsistent with a fundamental right, a court is prevented from declaring the truth of that inconsistency just because the laws form part of the inherited laws from a colonial regime must be condemned. So here's a very strong statement by the CCJ saying, you know, that this idea is something that we have to lift up, we have to interrogate, and the CCJ, for its part, says we have to condemn. And it says why. In Makaiwana, kind of a repetition of that, by shielding pre-independence laws, existing laws from judicial scrutiny, Savings Law clauses pose severe challenges both for courts and for constitutionalism. The hallowed concept of constitutional supremacy is severely undermined by the notion that a court should be precluded from finding a pre-independence law, indeed any law, to be inconsistent. We saw that already. Simply put, Sabin's Law clause is at odds with the court's constitutionally given power of judicial review. So here you have this hierarchy of ideas. You have human rights, you have the power of the constitutionally vested power of the Supreme Court to exercise judicial review. You have a supremacy clause that says the values are supreme, but you also have in the Constitution a Sabin's Law clause that says we save all laws. What do you do when the law you save is in conflict with fundamental rights? And so, whereas, as you know, the Privy Council said, well, we throw up their hands, can't do anything because the Sabin's Law clause is a provision in the Constitution, Constitution is supreme, so we can't do anything. CCJ said, well, and the CCJ is saying that because of this insight, because of its enablement, this insight into what we are as a people. That's why I started where I started, about a history of genocide and slavery and indentureship, of human trafficking, of forced labor. That is our history. Freedom has a different meaning. CCJ say you can't just sit down and say, well, no. And you create this idea of a hierarchy of rights, the privileging of human rights, major and minor tools, court power, judicial review, etc., and therefore it can intervene. Courts must interpret the Constitution in a manner that is consistent with international obligations. Another approach that the court is using. Legitimate expectation, I spoke to you about this already. I'll go very quickly because I'm going to just raise some distinctions with the Privy Council. So, ratification of the American Convention of Human Rights, though unincorporated, together with positive statements by the executive and parliament illustrating the intention to comply with the convention and the practice of the Barbados government of allowing persons the opportunities to petition, created this legitimate expectation. And therefore, you have to interpret the law in relation to the right to go to international bodies. Constitutionally, you have to interpret it in a way that takes cognizance of what the state is doing. You can't rely on the idea, it is not incorporated in domestic law, therefore it is not the law of the land, and therefore you have no business with it. No. And this is how the CCJ is creating Caribbean jurisprudence. Maya Alliance, I told you, there's a justiciable principle, the protection of law and the rule of law. The government believes had breached the Maya community's members' right to the protection of the law by failing to ensure that the existing land law system recognized and protected Maya land rights. You need to do what you need to do. And so the protection of the law, often seen as, prohibits governments from acting arbitrarily. That's bread and butter law. Right of every citizen to access courts, judicial bread and butter protection of the law. Here's what the CCJ says. The concept goes beyond such questions of access. It includes the right of the citizen to be afforded adequate safeguards against irrationality, unreasonableness, etc., etc. It may, in appropriate cases, require the relevant organs of the state to take positive action to secure and ensure the enjoyment of basic constitutional rights. And so that is the development of the protection of the law that the CCJ has taken in order to deal with a situation in which, because of the colonial inherited laws, Maya people had no recognition. Why did they have no recognition? North American Indian genocide was part of the project of colonialism. These people were othered. They had no value. They had no legal status. They were given no recognition. That was the agenda of empire. That is our colonial history. CCJ is cognizant of that, intervenes and says, under the protection of the law, find a way to give you freedom, to give you rights, to give you protection. Preambles, I'll go very quickly. Constitutional preambles as, quote, filling the Constitution with meaning and infusing, quote, life into the clay of more formal provision. So there's one kind of traditional approach. Preambles are not part of the Constitution, so you can't use them. Have to look at the provisions. CCJ is saying no. And it does that because it then finds in the preamble the rule of law as an implied principle in Caribbean constitutionalism. 3 cases there, Joseph and Boyce, Maya, McEwan. Preambles, even though they may not be separately enforceable, i.e. this idea of non-directed, but they can function at a minimum as an aid to interpretation. Certainly, CCJ has mined them and found as a fundamental constitutional principle the rule of law. Chandler, what is the Privy Council doing? Well, in Chandler, after Joseph and Boyce, in which Nerve and Joseph and Boyce and McEwan, but the CCJ develops its jurisprudence on the Savings Law Clause, as I told you, and does two things. It says that you must have the hierarchy of values, and you must have major and minor chords, and therefore Savings Law clauses must be read down to prioritize to privilege human rights. And two, that the protection of the law is a provision that can be enforced. So that's what they have done. That's what the CCJ has done in this trilogy of Nerve, McEwan, Bisram, and so on. So in Trinidad and Tobago now, the mandatory death penalty, they go back in Chandler, and now they say, well, look, hold on. All the CCJ jurisprudence on Savings Law clauses, because the Privy Council in Rudall and Matthews eventually overturned itself and decided that no, Savings Law clauses are in the Constitution, and therefore they save existing laws, even if they're unconstitutional. Well, you know, tough cookies. That's your law. We're not going to interfere. We leave it for Parliament. So in Chandler, the Privy Council would confront the CCJ jurisprudence and the Savings Law clause, and they would acknowledge, quote, that there are tenable arguments on both sides. In other words, they put down the arguments of the earlier boards and the CCJ arguments, and they say both are tenable. Yet, in the face of tenable arguments, the Privy Council would choose reliance on the doctrine of stare decisis, quote, standing by what has been decided, because this was, quote, a fundamental principle of the common law, i.e. the doctrine of stare decisis, and not depart from its prior approaches. Well, it begs the question, but hold on. When earlier panel had decided that they could modify the law, another panel changed it. But they rely, in the face of tenable arguments, reliance on keeping the status quo. I will leave that for you all to ponder. Privy Council acknowledges the unconstitutionality of several pre-independence colonial laws, but declares it's for Caribbean parliaments to effect reform, not for the courts. I say a remarkable position, given the principle of constitutional supremacy and the power, indeed the duty vested of constitutional review that is vested in the courts. I find that remarkable, that you can, where is the integrity in Simeon McIntosh's notion in that kind of jurisprudence? How can you say death penalty is cruel, inhumane, but it's not for us to intervene? Parliament. I suggest that that's because for the Privy Council, the ideology of parliamentary supremacy continues to influence its methodologies of constitutional interpretation. That's, maybe I'm wrong on that. That's how it seems to me. Let's see how we go along. The ACP's approach gives precedence to the Savings Law. CCJ has adopted a different approach. I've told you that. The result of this is that the Privy Council saves archaic, outdated colonial laws and changes them from constitutional challenges, ignoring modification clauses, and in full acknowledgement of the repugnancy of these laws as they relate to the Bill of Rights and to international obligations. In reliance on international obligations, the CCJ used legitimate expectation to, in effect, have a measure of incorporation, domesticity. The Privy Council has, in Thomas and Batiste, relied on international obligations, but through due process. So they say that's part of the due process. Protection of the law and the rule of law. Privy Council also part ways with the CCJ. And the board, as it says, is not persuaded that it's possible to erect the rule of law into a justiciable unwritten principle which can be separated and untethered from specific provisions. The principle of the rule of law must be considered in the context of the Constitution as a whole, and the Constitution interpreted as a coherent whole. So all the language is there. These provisions are, the board explained, disapplied by Section 6 of the Constitution. So here's the nuance. Privy Council is saying, interpret it as a whole, make it coherent. Section 6 is part of the Constitution, and so you have to disavow, you cannot disapply these unconstitutional laws. Privy Council looks at the same thing, it's saying we must apply the coherent whole, but in the what does coherence mean? The coherence of music is that not that every note has the same status. There are minor notes and there are major notes and there are rests. But for the Privy Council, every note is the same status. That is the difference in the approaches. So for the Privy Council to do what the CCJ is doing would undermine the coherence of the Constitution. If that which Section 6 has disapplied were to be applied through the invocation of the principle of the rule of law. Well, the CCJ is saying the principle of the rule of law in the modern era, and we need to distinguish rule of law. I think I come to that next, do I? No, yes, rule of law versus rule by law. I thought I did. But the idea of the rule of law and rule by law. Remember genocide of indigenous peoples, slavery, indentureship, all were under the legitimacy of law, the cover of law, I should say. Rule by law, passed by parliaments in the UK. Rule of law, and Lord Bingham agrees with this. Rule of law is different from rule by law. And one of the essential differences is rule of law has inherent in it fundamental human rights as constitutive of the rule of law. So when the Privy Council says you cannot disapply Section 6 by invocation of the principle of the rule of law, the CCJ is taking the same coherence principle but saying, hold on, when you think of major notes and minor notes, and when you think of the principle of the rule of law, which is not ruled by law, which Parliament did with slavery and indentureship and genocide and apartheid. No. Rule of law means fundamental rights have a special status. And so coherence in the music of the Constitution allows us to say the Savings Law Clause is different in the hierarchy of constitutional values. Has a purpose and function, has a narrow impact. Where it runs up against human rights, we can read it down. Well, you have to choose. In Chandler, the JCP would also part with the CCJ on the constitutional right, but I've covered this. So.
Often just I'm so sorry to interject.
No.
We're just at 1 p.m., so I'm just alerting you.
I see that, and I think I've gotten to the end. So I have my clock running. I'm seeing that I'm on 12:59, so I'm aware of that. So Van Gogh's conversation of potato eaters, regrettably, I don't think we have too much time to chat. I was hoping that Van Gogh would have encouraged us to have a little conversation about this last part, but Antonio, as a good disciplinarian, has held me to my good case manager, I should say, sorry, has held me to my time commitments, and we're out of time. If anybody wants to make, I think we can squeeze a couple minutes out of Antonio. I don't think he's going to be that draconian. This last little piece, anybody wants to say anything, make any comments, and then I will close off in literally 60 seconds.
Justice Jamadar, it's Andrew Mitchell speaking, and it's been a real pleasure and an honour to listen to you over the last couple of hours. I just want to ask you one simple thing, and that is the savings clause, of course, going all the way back 50 plus years. Wasn't it there designed to protect the human rights of the individuals in the countries that were being granted independence? And therefore, isn't the simple answer that the Privy Council have simply failed to look at and analyse why there was a savings clause in the first place?
Yeah, no, the point is well taken. in the negotiations, actually, I know the history in Trinidad. I don't think it's too dissimilar. And we must remember that in the 60s, and Lord Diplock writes this in the early judgments on constitutional law coming out of Trinidad and Jamaica. He says that the Constitution contains, because the common law of England contained the fulfillment or the fullness of human rights, right? And that may have been true at that time, but and so in that sense, the Savings Law Clause was put in there to ensure that for these newly independent states, there would not be, by majority governments, an erosion of, let us call it, British common law human rights, okay? On this idea that the British common law had within it the fullness of human rights. So yes, you are right. The Savings Law Clause also was to function as a transitional provision. So it's a typical thing, right? In anything, if you're moving, not just in a constitution, but you're moving from point A to point B, you want to have a measure of, and the Privy Council comes back to it in Chandler, it talks about certainty. You want to have a measure of certainty and stability in a transition period. So we save the laws. But of course, and so you are, I have to be careful, maybe diplomatic, but I have to be careful. You have said it, and so I can maybe rest on what you say. If the intention was both transitional, and 60 years on, I think transition has gone a long way. Trinidad is actually a republic. If it's transitional, and if the intention was the protection of human rights, then the CCJ's approach allows you to find a mechanism to not disavow savings law clauses, but to read them down where they are clashing with fundamental rights by this idea of coherence and a hierarchy of rights and a privileging of human rights and the rule of law as inherently including human rights. And so the board says, you know, both are tenable arguments, but it makes a choice, and it actually hangs its choice, which I must confess was disturbing to me, on the principle of stare decisis. You know, I don't want to say more about it, but I take your point, and I think that's something that, you know, I think it is well stated. Let me not say more than that. Anybody else wants to make a, is that okay for you, Andrew?
Yes, thank you, and I agree. I mean, I'm totally and utterly behind you, and understand and appreciate what the CCJ are doing, and I just want to try and understand why the Privy Council doesn't wake up to what it was there for, the savings clause, and why it's no longer relevant in a moving modern world in respect of moving and changing approaches to human rights.
Yeah.
Whereas it does have a reason to remain in respect of some fundamental laws. Exactly.
Yeah, anybody else wants to make a comment? Are there some comments in the chat? Larissa, you want to read them for me? I know that Antonio is going to be getting a little bit anxious.
Yes, Judge. Basically, there are comments saying excellent talk. Thanks very much. That's
Okay.
from Richard Bendal. From Justice Farnese, thank you for the excellent session and indulging my questions. Justice Rajnath Lee, I've enjoyed this tremendously excellent presentation. Congratulations, Judge.
Okay, all right. So no questions or other comments. All right, good. So let me just let me close off. Antonio, yeah? Let me close off.
Yes, certainly,
So-
Justice Jambadar.
Okay, so I just want to end and maybe the comment from Andrew kind of segues nicely into this. You know, the same article, this is what he said, this is his opinion. These cases involve constitutional construction of codified written constitutions, that is, where the constitution rather than parliament is supreme. In that context, the board's attempts to justify its decisions by deference to majoritarian democratic rule in i.e. parliament remain highly unpersuasive by effect of its failure to follow its own long-established principles of constitutional interpretation, such as a elementary, generous, and purposive interpretation of bills of rights, strict and narrow interpretation of derogations from human rights, the presumption that constitutional provisions are intended to conform with international obligations where there is ambiguity. And they do this, that is, he's criticizing the JCPC by focusing on language rather than intention, which I think is what Andrew was pointing to. But adding maybe to this comment, where the intention of a Savings Law clause was, among other things, to preserve and protect human rights. He then makes the point, quoting Lord Bingham from Bow, that constitutional adjudication of primary legislation under a written constitution is unfamiliar. This is what Lord Bingham says, and even resisted by some in the Privy Council, perhaps due to a conflation of two very different systems of governance. I'm ending there because I think that is the place to end, which is where I started. I think that, and we have to be careful that we do not practice a form of disrespect and arrogance and think that, it's so obvious. I think we're all shaped by our ethos. And I think that in a very real sense, the Privy Council, so I think the comment here of Lord Bingham, one of their own in Bow, is apt, that it is a challenge for some in the Privy Council, because constitutional adjudication of primary legislation under a written constitution is unfamiliar and even resisted, because in the UK, parliamentary supremacy is the ethos. That's the sea in which they live and breathe and move. That is the way, so that you defer to Parliament, But in constitutional supremacy, the Constitution has said power of judicial review is a power vested in equality. Why did these independent states do that? It's not undemocratic. Where there's parliamentary supremacy, maybe it's undemocratic, but not in a constitutional supremacy, not where there's constitutional supremacy, because the power given to courts, and maybe rightly so in developing societies, where small societies, where you are trusting this group of people you call judges to protect. And I take the earlier position, not necessarily communal rights, even though I just to end, I think in Maya Alliance, I hope that our Canadian colleague sees that the CCJ in Maya Alliance is trying to find a way to recognize the collective land rights of the Mayan people. So let us be not too judgmental as judicial officers, but a little more understanding. But in that understanding, let us also have the courage to follow the paths that we are called to walk upon. Thank you. May your journey into constitutional interpretation lead you in directions of constructive and evolutionary development, suitable for your own society. Chief Justice Antonio, friends, colleagues, Larissa, it has been enjoyable for us to prepare and present, and if it has been beneficial to you, then we are grateful.
Thank you so much, Justice Jamador, for that very informative presentation. I'll now turn this over to Ms. Tanya Carter for a formal vote of thanks. And right before I do so, I want to indicate that you're getting a lot of comments in the chat congratulating you for a very informative presentation. So we thank you very much for that. And I'd like to read the comment of Her Ladyship, the Chief Justice, if you would permit me.
Yes, it's in your hands. I've finished, Antonio. You now have full, you are on the stage. I have walked into the curtains.
Thank you very much. Her Ladyship indicates excellent work. Judge, very grateful for the thought-provoking presentation. And thank you as well to Ms. Pena. So now I'll hand this over to Ms. Tanya Carter.
Good afternoon, everyone. And once again, it is my honor to present the vote of thanks after today's session. To Justice Jamador, we say thank you for your very thought-provoking and detailed presentation, which has helped us to understand that a constitution has characteristics of its own and that it is a legal activity in its own right. We better understand now that a constitution is an ever-evolving species, which is more than the sums of its written provisions. Your presentation, as always, has given us food for thought, and no doubt our judicial officers, attorneys, and other attendees will consider all that you have said as it relates to constitutional interpretation and how we can act as agents of constitutional change in our respective societies. Once again, we say thank you to our attendees. We thank you for your attention, your participation, and your valued contribution in today's session. On behalf of the Honorable Chief Justice and the Chairperson of the JEI Committee, as well as the members of the JEI Committee, we say thank you to all. I now hand you back over to Antonio, who will close off today's proceedings.
Thank you very much, Ms. Cotto. So I'd just like to say good afternoon, everyone. Thank you once again, Justice Jamadar, Mrs. Pena, and we hope to see everyone tomorrow for a final day of Judicial Education Week. So good afternoon, everyone, and thank you for attending.